Must be what's there.
The lack of air conditioning, we're fine on the second floor, it's just the third floor. No.
Henry, can you buzz Rick? Otherwise, I think we have everybody.
We got a couple more minutes.
Right?
And
Oh, no.
Yeah, but it was loud.
I can go.
Always turn it on. Tim, you wanna flick the fan and we can evaluate noise levels? Cause it is very hot.
That's fine. How is that for everybody, or do we just need to speak loudly? Tom, is that good for you, or?
It's not, it'll depend on, Joe, why don't you talk and see how it sounds from there?
On the Zoom, I don't notice any difference with the fan on.
probably be able to hear me.
I can hear you. Okay, yeah, let's try it. Let's try it and go from there.
Anybody online, does that fan bother the noise online?
This is Wendy Weigler. I can hear fine. Can you hear me?
Yep.
Okay, thank you.
Okay, so I
This is
think,
Kristen Decker. I can hear fine as well.
okay, thank you.
We can go ahead and start. Suzanne's gonna see Brian might still be in. Go ahead and
We'll
start.
just pop in when it can.
Mhm.
Okay. I'll call the meeting to order. My name is Tom Smith. I'm the Pitkin County Hearing Officer. It's Tuesday, July 16th, 2024. We're in the Room Bells Meeting Room at the Pitkin County offices at 530 East Main Street. We are here on the application for approval of activity envelope and site plan for the property at 1200 Star Mesa Drive. And I want to tell you how we're going to proceed. So phones are off, I hope, so we don't have to deal with that. You need obviously devices for staying in touch with the meeting and doing your presentations, that's fine. The process we're gonna follow is after my comments, we'll go around the room. Starting here and then finishing up with the two in Denver. After appearances, we'll start with Tammy presenting the application for the county. Then we'll hear from the applicant and then from the various objectors. You can make any comments you want, but you should be aware that I've read and studied the application. Familiar with everything that's already in the file. You don't have to repeat what has been submitted in writing. I'm not going to tell you you can't, but I just want you to be aware that it's not necessary to repeat what's already been presented in writing. Okay.
I'm gonna pause you just real quick.
Yeah.
We lost the owl microphone.
Got turned off, I believe. We turned back on.
Yeah.
I think the mute is on there. Yeah,
This one's on?
No, it's on the other side. Can you hear it now?
No,
Is it?
here we go. Can we hear now?
Testing, test.
There was a red light on a second ago that's not
I
on now.
think the red
Yeah, I
light.
think that-
Not picking up
Hello?
the mic.
Hello?
Now it is. Okay.
Alright,
Can you hear us now?
good off on, did it?
But it's not showing the video now.
Oh, yeah. There it is.
There we go.
And are we good on sound online?
Yes, it's good, and we can now see you again. Thank you.
Okay, did everybody hear my opening comments? Wendy and Kristen, yeah?
Yes, we heard
I
them.
heard them.
So we'll start on my left. Everybody in the room, just state your name and you want affiliation or representation, and we'll go around the room and then I'll hear from Wendy and Kristen for their appearances. So,
I am Sankta Shabi, the owner of the Brattleboro parcel.
I'm Jacqueline Shear, and my husband and I are the owners of the Penobscot parcel.
Neil Shear.
Diane Utz with Artemis Construction Management. I'm here on behalf of the applicant.
David Johnson of DJA Architects on behalf of the applicant.
Joe Craybacher on behalf of the applicant.
Bonnie Files, admin for Picken County.
Tammy Cochin, Picken County Planning.
My name's Glenn Horn on behalf of the applicant.
I'm Cody Horn, on behalf of the applicant.
David Gersten, Harvard, 10.5 Star Mesa West Cliff parcel.
And Suzanne Wolf, Community Development Director.
And then we have 2 participants online.
Wendy first.
Hi, I'm Wendy Weigler on behalf of Star Mesa Homeowners Association.
Kristen.
And hi, I'm Kristen Decker on behalf of David Kirstenhaber as general partner of GRE2 LP.
Now Kristen's volume is down too low for me. I could barely hear you. If we can fix that before you present, that would be helpful.
Is this any better?
No,
Okay, I might just have to yell, at least for me.
All right, so I'm gonna turn it over to Tammy for introduction of the application and presentation of the staff report and recommendation. Tammy, well, as we all know, there are some legal issues presented by this application. I'm not expecting you to comment on those. I just would like to hear from you regarding the process so far and in summary, and then to comment on the land use applications and your recommendation as well as the proposed hearing officer determination.
All right,
So far away.
okay, so, everyone in this room was just on site, so I don't need to do any of that location or background information. This is an application for activity envelope and site plan review approval. And that is to construct a 15,000 square foot single family residence with a driveway, OWTS, landscaping, ponds, water features, a pool. And that activity envelope will encompass all of that work as well as Star Lake. This on the screen is the proposed activity envelope and site plan. This application was sent to Tom Smith, based on the objections submitted by Wendy Wiegler, who states she is, representing the HOA of Star Mesa. The referral agencies that this application was sent to are shown on the screen. We also received letters from Richard Klein as well as an attorney representing the Aspen Kiwi Trust Company. And also a letter from Kristen Decker, who represents the West Cliff parcel. All of that information was in the packet. I have not received any new information or material since that packet was published. So nothing has changed in regards to staff's recommendation for approval. Staff still finds that this application complies with the land use code, specifically chapter 7. And the constraints listed in chapter 7, such as wildfire, wildlife, steep slopes, geologic hazards, the irrigated pasture land section of the code and so forth. And because Tom has reviewed the packet thoroughly and staff has no new information, I'm not gonna present any more unless there's questions on specific aspects of the code or Tom wants to
So
hear more
nothing's
about it.
changed for you
Nothing's
since you
changed.
submitted the packet to me.
Correct, and I have all the drawings that were in the packet, we can pull up if anyone needs reference.
The record to reflect, we now have Lenny Oates. Lenny, are you here for a client?
Yes, I represent Aspen Kiwi Properties. And I'm just observing.
Thanks. All right, so Tammy, thank you. The applicant's turn. Joe, I assume as counsel, you're taking the lead?
I just want to make a quick comment, and then Glenn will take over on the land use application. Again, it goes to the legal issues, and I just wanted to mention, which is maybe not in the packet, that the acting county attorney, in order to resolve the question of whether the association had authority to file the objection to begin with, which triggered this process, recommended filing a statement of authority. As of this morning, when I searched on the county clerk and recorder's records, there was no statement of authority. I printed out just a short sheet showing what has been filed, but there's no statement of authority. Just reiterate that we contend that the association didn't have authority to file the objection and to take this to a hearing officer. That's it.
Glenn?
Okay, thank you. I want to begin by entering the affidavit of public notice into the record with Bonnie. Please let this be in the official record. So, I represent Star Sky Holdings LLC, the applicant. Also here representing the applicant are Diane Utz, who's the owner's rep, David Johnson, the architect, Joe Kraybacher, the attorney, and Cody Horn, who is assisting me with the land use planning for the property. It's the Lotawana parcel located in Star Mesa. We're seeking activity envelope and site plan review. This is a slide which shows the 6 parcels that make up Star Mesa. McLean Flats Road on the west, Woody Creek Road on the east. The mesa sits north of Starwood, and it bifurcates the 2 valleys, and it's highly visible from McLean Flats Road, Highway 82, Upper River Road, Brush Creek Road, and scenic foreground review, scenic protection review is a critical consideration in planning the property. The 6 parcels are the Bradford parcel on the north end of the Lotawana. Tom, you'll recall we did an activity envelope site plan review about 9 years ago on the Bradford parcel, and the driveway linking the Lotawana parcel, the Bradford parcel, Star Mesa Drive, was relocated as part of that review. The Brattleboro parcel is located here, developed with a single family house. The Penobscot parcel, the Westcliff parcel, and the Rondelet parcel. I want to mention that every structure, every parcel up here has the main structure or a portion of the accessory structures breaking the ridge line as viewed from county and state right-of-ways. So there are ridgeline breaks on every parcel except the Lotawana, which is not yet developed. Some background, the parcel was acquired by the applicant in 2015. When the parcel was acquired, the applicant hired David Johnston, Joe Kraybacher, and I to do the land use due diligence. As part of that due diligence process, we looked at the 1975 land division, which created the 6 tracts. As you're aware, Tom, that was challenged, and there was a lawsuit that went to Supreme Court concerning the right to divide 35-acre tracts and be exempted from land use reviews. The outcome of that process was an agreement in 1984 called the Penobscot Agreement. As part of that agreement, it called for the HOA, the county was a party to that agreement, to establish covenants that included locations of building envelopes, or they were called designated building sites. In that agreement, there are some key concerns that are going to be really the focus of this review and the presentation. One of the key clauses was said that residences and accessory buildings shall be located at the perimeter or edge of the meadow, which now exists in the center of the property. The agreement called for a substantial portion of the existing central meadow not be encroached upon by development and to remain in open space. And on lot 5, which is the Lotawana parcel, it said that development should be located east of the 80-50 line. And we kind of looked at the 80-50 line when we were out there. That's where the parcel breaks over the hillside and starts to drop down towards McLean Flats Road. It's also where the vegetation changes on the parcel from field grass and pasture grass to dense serviceberry, chokeberry, and gamble oak shrubs. So if you back up, you can see the break right about here where the open meadow on the Lotawana parcel goes over the ridge, and that's where the steep slopes start. The 80-50 line is right along that vegetation break. This slide shows 3 designated building envelopes that have been approved by the Star Mesa HOA over time. First in yellow, you see a yellow dashed line. This is the 1986 envelope. This was the envelope that Andre Ulrich designated on the Lotawana parcel when the covenants were first created in 86. A key line right here is the 80-50 line at the top of the vegetation change, at the top of the slope. And the covenants call for development to be located east of that line. To give you directions, here's the north arrow. So north is the top of the page, east is towards Woody Creek, west is towards the Roaring Fork. So there is ample room to the east of the line in the 87 envelope for a house to be developed. However, development of that house would require compliance with Pittman County land use codes and the scenic view protection. This is the 2015 designated building envelope shown in white. This is the envelope that was approved by the Star Mesa HOA in 2015 prior to the acquisition of the property by the applicant.
Can I just make a quick clarification, Glenn? So it was
before you
approved by
talk,
the
hold on, Joe.
owners.
Yeah, Joe, for the record, when someone new talks, you need to identify yourself
Okay.
first so that the recording can, if it needs to be transcribed, we'll have your name.
Okay, yeah, Joe Craybacher, representing the applicant. I just wanted to clarify that the envelopes were approved by the owners as opposed to the association.
Okay, so here you have an activity envelope in which landscaping, driveways, water features, and the septic system would be located, and the building envelope, the designated building envelope, in which the house will be located. Here is an exhibit that we looked at on the site. This is the 1987 envelope. This was the HOA approved envelope that was in place in 2015 when the property was put under contract. So at the request of David Gerstenhaber, we set story poles on the east side of this envelope at 9 feet, 31 feet, 26, 21, and 25. These story poles at those heights are not visible from McLean Flats Road. However, they are highly visible from Highway 82, up valley of Cozy Point Ranch, and all of these story poles break the ridge line. It should be noted that as you move in a westerly direction towards the 80-50 line, the height of a house that could be developed in this envelope that would not break the ridge line from McLean Flats Road decreases in height significantly. When you get to right here, it would be just 10 feet. At this point, 7 feet, and 3 feet on this side. We concluded in 2015, when we were doing our due diligence work, that it would not be possible to build a house in the 2015 designated building envelope that did not break the ridge line. So as part of our due diligence,
Joe Kraybacher again, sorry. I think you meant to say the 1987
correct,
as opposed to the 2015.
yeah, the 1987 envelope. As part of the due diligence analysis, we met with Lance Clark, who was then the Deputy Community Development Director for Picken County. We discussed with Lance the applicability of the Penobscot agreement to this parcel and what could be developed. Lance informed us that a house could be developed on this parcel exempt from growth management, and it could be up to 15,000 square feet in size. Lance also made it very clear that the other standards of the code in Chapter 7 would apply to site development. Although the property is exempt from growth management, it would be required to comply with all other standards. We determined through story pole analysis in 2015 that the 1987 envelope could not accommodate a house in compliance with the scenic view protection standards of the code. So it was not possible to develop a house within the 1987 envelope, which was approved by the HOA. We then studied the property to determine a designated building site that it could accommodate a house. And we we located the envelope, we did story pole tests, and determined that the 2015 envelope could comply with the county's ridgeline review. And members of the HOA signed consent letters, a majority of them approving the 2015 designated building envelope. Based upon the approval from 4 members of the HOA, the applicant moved ahead and acquired the property. This slide shows the 6 parcels on Star Mesa and the designated building envelopes that have been approved by the Star Mesa homeowners, including the 2015 designated building envelope on the Lotawana parcel. So in citing this envelope, we had to look at the direction from the Penobscot agreement, which said you must be east of the 80-50 line, and the Picken County Land Use Code, which said we could not break a ridge line. We also had to consider this language here, which says residences and accessory buildings shall be located at the perimeter or edge of the meadow, which now exists in the center of the property. We were faced with the challenge of locating a designated building envelope that complied with the Picken County Land Use Code and the direction of the agreement between Andre Ulrich, Star Mesa homeowners, and Picken County. We located this envelope. The eastern edge is 160 feet from the property line. The front yard setback in the RS20 zone for a parcel this size is 100 feet. So the house could be no closer than 100 feet to this east property line, and it's located 160 feet on the edge of the meadow. I'll point out that the other houses on the Bradford parcel, the Brattleboro parcel, the Penobscot parcel, Westcliff, and the Rondelet parcel are all located at the far edge of the meadow, but each and every parcel has structural elements developed on them that break the ridgeline from Woody Creek Road or Highway 82. The Lotawana parcel will be the only parcel in Star Mesa when developed that doesn't have a ridgeline break. This is the activity envelope and site plan that we looked at on the site. all of the structural elements of the house are within the 2015 designated building envelope that was approved by 4 members of the HOA. Their consent letters have been recorded. This is the activity envelope that was approved by 4 members of the HOA. It will contain water features, landscaping, the driveway, and the septic system. This is an image of the house that's from this viewpoint. It would be where the driveway crosses the northeast corner of the Lotawana property, looking back to the south. So you see the image here without any trees. This is about where the driveway enters the Bradford parcel and the Brattleboro parcel. Here you see the image with no new trees. This is the image with new trees added. If you look at elevations, you're looking at the south elevation here, the east elevation, the north elevation, and the west.
Could you go back 1 second to the south and the first set?
I don't want to have anyone interrupt. If you want to talk, ask me, but before you do, because otherwise things get kind of crazy. So at this point, this is time for the applicant's presentation. And you'll get a chance to
I
talk.
just didn't get to see the first one.
If there's something you don't understand, then that's fine. Ask Glenn. We can have you clarify. Go ahead.
I'm sorry, I couldn't see the first elevation. Please. Thank you.
South, east.
Okay, and then I can see the next one. So
Okay.
sorry to interrupt.
So
Oh, I didn't see the second one.
north, west.
Thank you.
Okay, activity envelope and site plans are required to comply with chapter 7 of the code. Tammy's found in her memo and in the draft hearing officer determination, the application complies with the standards for site preparation and grading, steep and potentially unstable slopes, geologic hazards, water courses and drainage, wildfire and wildlife, renewable energy uses, irrigated lands for crop production, and scenic view protection. The applicant has come up with a plan for the only structure in Star Mesa that won't break the ridge line from designated scenic corridors. The house is located at the edge, the eastern edge of the meadow on the Lotawana parcel. The application complies with the code and also satisfies the direction of the agreement between Pitkin County and Andre Ulrich that's known as the Penobscot Agreement. With that, I would say that the conditions of approval suggested by the county staff are acceptable to us, and we ask that you approve the application.
Anyone else on your team, Glenn, that wants to add anything?
Joe, you want to add anything?
No.
Cody?
No, David Johnston, no.
Okay, so I'm gonna make it easy. We'll go around the room from my left. In order, and you have a comment, identify yourself. Go ahead. I'm no 3-minute time limit, but try to be concise.
Tom, before that starts, if you don't mind, since this is not my area of expertise, I'll let Kristen, who represents me, speak before me if I have anything to say.
Yeah, okay. Go. Thank you. That's fine.
So mine will be pretty short.
Name for the record.
My name is Sankesh Ravi. I'm the owner of the Brattleboro parcel. I purchased my property a couple of years ago. And I was always kind of, when I purchased the property, one of the big aspects was this open field that I think everybody has enjoyed at the Mesa. And so I don't know the history of the approval of the homeowners association, but in my current standing, I wouldn't approved this to be moved to this area. Given that it's right across my driveway, blocks a lot of views, and I think most importantly, it's for maximizing square feet, and I think there's a lot of wildlife that is there, that's beautiful and that needs to be preserved. And I think you can build a house, we were there today, I think you can build a house where the building envelope was originally approved, so that's kind of all I have to say today.
Thank you.
And are you in support of the application?
I'm not in support of the application.
Hello, I'm Jacqueline Shear, and I have prepared this individual statement to address what appears to be a lot of confusion regarding the Lotwana parcel. I would like to add to the official record of today's hearings the bullet points that I'm reading today, as well as my official statement. I'm here today as the only individual who has had an actual, oh, excuse me, I need to share. Can you take your sharing off the screen, please? Thank you. I am here today as the only individual who has had an actual history and dialogue with the Ulrichs, who first developed the Mesa. My views are not based on conjecture and guess, as others frequently do. As I have managed the Star Mesa's Homeowners Association for over 20 years, I wish to provide some clarity in response to Mr. Krabacher's June 11th letter. These clarifications consist of Mr. Krabacher's description of the location and character of the open meadow, which is inaccurate and tailored to meet his client's desires, not reality. My exhibit 1, starting in the left-hand lower corner, you can see the snaking switchback of Star Mesa Drive, which is very steep. This is not a meadow, but a steep slope. At the top of the switchback is the Rondelet parcel and the Lotwana parcel on your left, where we first parked today. These two parcels, along with the third, the Bradford parcel, are noted in my column B. At the top of the page, you'll see column A and next to it, column B. You can see that 3 of the 6 parcels, including the Lotwana, have land that is not in the open meadow, as that land is on the slope. Please refer to where I have written slope in column A. Column B is where 3 of the 6 homes are allowed to be situated, on and across the ridgeline of Star Mesa. The shared open meadow is easily observed. This understanding of what the meadow is from Andre and Yoti Ulrich, who originally established the Mesa. No guessing, no pontificating, or sophistry is necessary to understand what the meadow is and what the original concept of its protection was. I also show the unsanctioned proposed activity envelope, the reason we are here today. The theory of the meadow that Mr. Krabacher developed, for the record, is an incorrect interpretation of Section 5 of the settlement agreement. What matters is that the proposed activity envelope is clearly in the shared open meadow and not in the 1987 amended building envelope set forth in this association's covenants. And I point out to you, page 7 is on the right from Mr. Krabacher's and the applicant's application. And you can see the flip corner rectangle, which is the shared open meadow, and the unsanctioned as in the open meadow applicant's home today. Regarding Mr. Krabacher's remarks about the Bradford parcel in 2016 on his page 3, Mr. Krabacher stated that the development of the Bradford parcel was the subject of a previous challenge in 2016 by me. Mr. Krabacher said that this objection was denied by the hearing officer, and the house subsequently remodeled and expanded. The fact of the matter was the objection dealt with a proposed new driveway to the Bradford parcel that included an unnecessary driveway spur located on the Lotwana parcel. The actual outcome was the applicant agreed to eliminate the spur as it was exposed as an attempt to extend a driveway and set the stage for future development on the Lotwana parcel in circumvention of county land use procedures by approving significant development without proper site plan approval. In the end, the spur was removed and the other development was able to go forward. The real point is the applicant has been trying to push development of this location in the Central Meadow through questionable actions for years. Regarding Star Mesa and also the Mesa's other 3 parcels and owners not previously mentioned. On the exhibit are 5 improved parcels that have development on the ridgeline of the Mesa. A precedent has clearly been set on how development is to occur on the Mesa. The 3 westerly parcels from their ridgeline envelopes are oriented to the west, leaving the shared open meadow open for all to enjoy. The location of the building envelopes was done, I think, on purpose to provide for this wonderful site planning reality. It is important to note that each of the improved parcels have built anew and remodeled solely on the ridgeline, some after the 2006 Scenic View Ridgeline regulations were enacted. This development has been allowed to proceed by the county based on precedent and the clear determination made in the settlement agreement concerning where development could occur. The county has required vegetation to be planted to soften the ridgeline impacts, but has approved this development. This is a second precedent that the county has been able to approve development on the ridgeline. It is important for us to hear as well the incredibly thoughtful language of the code that was crafted with needful anticipation and of the necessity to honor grandfathered agreements between the county and homeowners associations. Following are the noteworthy words of the Pitkin County Land Use Code, section 720-120 E5. The proposed structure shall be placed so it does not project above a ridgeline. The structure shall not silhouette against the sky when viewed from those corridors listed in subsection B. 12 words. Unless there are no alternate building sites on the lot or parcel. No alternative sites exist that would be compatible with the original site planning of the Mesa, and that would meet the 1984 county agreement. The applicant furthermore has not provided to the homeowners association nor to the county that 3 of the 6 easterly parcel representatives here that are here today do not support the relocation of the applicant's envelope. So there is no majority to move ahead for the applicant's submission. Part 2. The second objection on page 8 in Mr. Krabacher's June letter. 1. Mr. Krabacher's assertion that the activity envelope was approved by the association and or the homeowners is invalid. The attorney represents only 1 of 6 parcels and can only speak on his client's behalf and not for the other 5 parcels. Nor can he speak for the association. Secondly, Ms. Weigler, as the attorney for the association, has provided that the covenants, articles of incorporation, and bylaws are clear on the matter of voting and the function of the association, and that Mr. Krabacher's understanding of these documents is truly flawed. Mr. Krabacher states that Pickens County is not a party to the declaration and notes the Colorado Revised Nonprofit Corporation Act. Ms. Weigler is correct in her interpretation of the aforementioned act. And sadly, again, the applicant's attorney, for the record, is incorrect. With much smoke and mirrors aside, this hearing is not about a dispute among the owners in the Star Mesa Homeowners Association. This matter is in fact about the fact that not 100% of the homeowners consents to the development. It is the county's duty to abide by the facts presented by the attorney of the association and not to the interpretation of an applicant's self-concerned viewpoint. What one selling homeowner did 9 years ago to ensure the sale of their property to the applicant should be thrown out. I, acting as the president of the association, notified the then seller in writing that the association could not and would not vote to relocate the envelope to facilitate a sale without being presented with details from their land planner, their architect, about the vision of the project, particularly with massing and location of the residence and the location of the driveway to access the residence. Needless to say, not even a sketch was ever provided for homeowners to see their ideas, and hence there could be no informed consent reviewed, distributed, or voted on in an informed manner. Star Mesa Homeowners Association and my role as president, and page 12 from Mr. Krabacher's letter. Concerning Mr. Krabacher's issues regarding officer issues and the conduct of the homeowners meetings, it is important to note that the applicant was in good standing with his homeowners association account and that he regularly paid his assessments and never had a complaint to make in his 9 years of ownership about the association and its operation for the maintenance of the Mesa. In fact, for 9 years until recently, the applicant's representatives were very grateful and complimentary for the annual updates and contributed to capital cost needs for shared issues like road improvements and shared irrigation, ditch and piping needs, etc., per the annual budgets without complaint. Moreover, no one ever had a problem with my signature as president for banking, insurance, and everything regarding the association and upholding the governing documents. Mr. Krabacher's pages 12 to 13, Brattleboro parcel voting agreement story. For the record, I was told by the attorney for the current owner of the Brattleboro parcel, Mr. Abbey, before he purchased his property, that Mr. Abbey was contacted by the applicant's representative who wanted to have Mr. Abbey align with the applicant for any future building issues on the Lotwana parcel. The attorney for Mr. Abbey explained that Mr. Abbey was against any and all building in the open meadow, and he wanted the building envelope of Lotwana to remain on the ridgeline per the covenants. To this end, Mr. Abbey wanted to negotiate an agreement with me, which we did, but not according to the baseless story from Mr. Krabacher, excuse me. To clarify, firstly, yes, the boundary line agreement was entered into after the land use application was submitted. Secondly, the agreement was not, and I quote, in a transparent effort by Scheer to garner opposition to applicant's land use application. End of quote. It was rather a neighborly offer to provide additional land for the Brattleboro parcel to avoid any issues with their parcel size due to a surveying error. Finally, the Brattleboro agreement originated in response to the applicant's attorney, Mr. Krabacher, who knew that the 2015 consent was on shaky grounds, not only in its origins, but in its distribution, and most importantly, the feebleness of the 2015 consent's validity. The current representative of the Bradford parcel, not present here today, nor represented here today, openly disclosed that his hands were tied with regard to the applicant's current application, as there was a signed agreement when he purchased the property to not object to the application under discussion today. This again demonstrates that Mr. Krabacher himself doubted the validity of the non-sanctioned 2015 consent to relocate the envelope. Mr. Blum, in 2015, the prior owner of the Abbey parcel, received an offer of a triangle piece of land that had an easement over it to be cleared of the easement in exchange for his support of the Lotwana application to be in the shared open meadow. And this trick worked out for the applicant. C. Regarding Mr. Krabacher's trying to associate modifications to other envelopes on the 5 parcels he does not represent, is the attorney's last-ditch, desperate attempt to establish a precedent for the applicant. The minor modifications to the envelopes are inconsequential and had no impact to the fact that the 5 neighboring parcels do not have envelopes in the shared open meadow. Part 3, conclusion. Based on the foregoing, the hearing officer should not approve the land use application. I appreciate your thoughtful reflection of the 1984 agreement between Star Mesa and Pickens County Board of County Commissioners and how it meshes with the 12 words of the scenic ridgeline regulations, allowing exceptions for building on the ridgeline, unless there are no alternate building sites on the lot or parcel. In summation, the relocation of the building envelope has not been properly approved by the association. A precedent has been established that development can occur on the ridgeline, and that the ridgeline envelope for the Lotwana can be softened with trees, as was done on the Star Mesa's Bradford and West Cliff parcels. It is important for the county to stand by its word by preserving the shared open meadow. Thank you.
Thank you, Mr. Chair.
Thank you.
Mr. Chair, you want?
Yeah, Neil Shear, I have 3 quick points that I would like to make. First of all, the applicant bought a property that he knew in advance had potential impairments on it. That it was not a clean purchase of a property that he could build in moving the lot, and that was well known in advance. Secondly, he may have based that on an illegal vote that was orchestrated by these 2 gentlemen here, Mr. Craybacker and Mr. Oates, in a Keystone Cop-like manner, almost to the point of being ridiculous. So they bought an impaired property. Number 2, neither Pitkin County, as represented here today, nor 4 lot owners can vote away or authorize the building of this lot in impairment of my view of the open meadow. I have, and I'm not a lawyer, a contract with all the landowners of the sanctity of the open meadow, and you can't reverse that under any conditions. And the third thing, which is quite obvious, and Mr. Abbey pointed out, it's not clear that a house cannot be built on the pre-existing site. And this is being done purely for economic purposes to try to build 15,000 square feet in an economic environment, in a housing economic environment in Pickett County that we all know is roaring. So I would really like the hearing officers here to reconsider what they've written and submitted already to us as their preliminary findings. Thank you.
Thank you, Mr. Shear. I think we've heard from the applicant side. We'll go to our out-of-town guests here. We'll start with Ms. Decker, please. Identify yourself, your representation, and your comments.
Good afternoon. My name is Kristen Decker. I am representing David Gerstenhaber on as the general partner of, as I've already mentioned, GRE2 LP. Mr. Smith, as requested, I'm not going to repeat everything that is in my letter. I would like confirmation that it is included in the official record, though. I asked this question because there's a strange statement in the draft determination that my letter was submitted after the December 8th comment and objection deadline. There were 2 other letters submitted from 2 other law firms on behalf of adjacent landowners, and that same statement wasn't in there. And so I'm just a little confused as to 1, why it was in there, and 2, just want to ensure that my letter is included in the record.
Let me respond. Your letter is dated July 9, is that correct?
That is correct.
I have it and I've read it. Thank you.
Thank you. In summary, I do not agree that the scenic view protection regulations apply to this application. The effect would be a direct conflict with the 1984 contract terms for all the reasons I explained in my letter. The application is not consistent with the land use code provisions that are cited in the letter, specifically dealing with the wildlife and the habitat due to the encroachment into the meadow by this new relocation of the building envelope. Lastly, because the 2015 relocation of the envelope was not approved by the association, approval of the application would constitute a breach of the 1984 agreement by the county that's binding on the county and all 6 property owners in the area, in the Mesa. And you know, even though I feel like we get a little flack for being Denver attorneys here, but even though I'm a Denver attorney, I have visited this site and I'm often in the area. I'm very familiar with the effects of the relocation of this envelope, and I understand the impacts All the other property owners have substantially complied with it. This is the only property owner who is not complying substantially with the declaration and the 1984 agreement. Granting an exception by approving this relocation of the envelope will have significant impacts on the area that should be avoided. For those reasons, the application should not be approved, and I thank you for your time.
Thank you, Ms. Decker. Ms. Weigler or Weigler? I'm not,
It's Weigler,
sorry.
no
You're-
problem. So for the record, I am Wendy Weigler. I represent the Star Mesa Homeowners Association. And the Homeowners Association's position has been stated in the 3 letters submitted that are part of the record, and I do not have anything further to add. Thank you.
Thank you. I have read both of your letters and I'm familiar with them, and I appreciate your brevity at this point. But I will address the issues you've raised before we're done here. Lenny, did you say you're?
No, I'm just an observer.
Okay. You've gone, David, your turn. If
Thank
want to
you.
comment.
David Gerstenhaber, West Cliff, 1025 Star Mesa. I think this is a very unfortunate hearing, which is how I would start things off. The Mesa has been a very peaceful place until this war, as it strikes me, has erupted totally unnecessarily. And it makes me very unhappy. I've been there since 2005. Jackie's acted as the president of the HOA extraordinarily effectively, and I've helped as necessary in the process. And the place has run really well without any conflict whatsoever. It is true that there has been a lot of subterfuge, backhanded dealing, hiding of information, and really bad faith in terms of how things have occurred with respect to the Lotawana parcel. That's not how I like to see things happen. In fact, I believe in neighborly, which was a word that Jackie used, and for what it's worth, Star Sky Holdings, not Star, whatever the name of the owner. Star Sky, for roughly 18 years or something of that sort, used my electricity to run their pond. Regularly flooded the base of my driveway in the process, and apparently within the last year, they got their own metered electricity within my property to run their pond. But the point is, it's a nice pond, and I said, fine, I'll pay for the electricity. I didn't charge them back for it, and that's kind of how things ran up there. It's pretty up there. I asked, by the way, for the record, the Aspen Kiwi property is thoroughly visible from all of the points that were referenced, except that it's screened by trees. If you work hard with binoculars, you can see through the trees in certain places, but Neil and I went down there yesterday to all of the relevant places that were mentioned. But by the way, the building envelope in question, the original one that's being discussed here, certainly cannot be seen from McLean Flats Road because there's a very large complex in White Star, which blocks it. And obviously in the same fashion that which one is Bradford is the Aspen Kiwi parcel, whichever the Aspen Kiwi parcel is screened from view from the distant views. Likewise, the Lotawana parcel, if a home was built easily within the building envelope, could be screened as well and made pretty. I asked, and the point about neighborly is, I asked repeatedly, indirectly, politely, and it's a small community, and I like friendliness. Everybody knows everybody here. For story polls and massings, as Jackie did, for the suggested new envelope, which is legally suspect, and the existing envelope. What do you guys want to do? I then asked multiple times through my attorney, Kristen Decker, to speak to Joe, to ask for exactly the same thing. We see each other in various social settings. It was only after my letter of objection went in on Tuesday, that the large line of story poles on the west side of the mesa that everybody saw today went in. And it was only approximately midday today, before all of us arrived, that the story poles for the suggested new dwelling went in, which really speaks volumes about the fashion in which the applicant is trying to deal with his neighbors in a small community. By the way, I'd make note that the proposed new activity is 160 feet from the edge, whereas it could be 100 feet from the edge. And I don't know the difference in terms of what that would make with respect to how everything would look. But all I consistently asked for was, show us what you want to do. Okay, let us view it. And so now, over the last handful of days, we have 33-foot tall story poles. Nobody needs to build a 33-foot house. All of the existing houses, which presumably break the ridge line, were remodels of houses that predated. This is really important. Remodels of houses which predated the scenic corridor issues, or whatever they're called, that Pitkin County has. And so the fact that they break the ridge line, they were grandfathered in. And to the extent necessary, those houses have all worked to mitigate through foliage, trees, etc. Nonetheless. So I don't like the way this has gone down. I think it's illegal. I think if this persists, i.e. if this is approved by the county, all that's going to happen is that the homeowners, who are at this point incensed wholly by the way this has been dealt with in a small community, will simply continue to raise this to higher legal levels, which will impede for years the development of the parcel and continue a war in a small community, which has been wholly unnecessary because of double dealing or backhanded dealing or secret dealing, when open dealing really should be the way things should happen. That's all I have to say.
Thank you, David. Jamie, do you want to respond to anything that's been raised on?
Sorry, before we move on, there are 3 people online.
Oh, I didn't realize.
Yeah,
I'm
make a
sorry.
note. I asked all 3 if they wanted to be promoted to panelists. Al Willer, David Foster, and a Savan Horn. All declined, so I'm assuming they have no comments. If that changes, please push *9
Yeah.
and I will update you.
Could you tell us who these people are?
Al Willer, David Foster, and what is listed as a Savan Horn. S. Van Horn.
Do any of those people just mentioned who are online have comments they want to make? If so,
Press *9, please. Or accept allow to talk.
I'm not seeing any desire to speak.
Nope.
Okay. Thank you. Tammy, did you have anything in response?
Can anybody just dial in?
Sure, it's a public hearing. We
Thank
do
you.
our business in public here whenever possible. Yeah.
All right.
I'm happy to respond to any specific questions.
No, just want to know if you had any comments.
Nothing more.
I'll allow the applicant a brief period of time if you want to make any response. I understand a lot of these legal issues that I'm prepared to address, but I'll give you a few minutes, Joe or Glenn, if you want to respond.
I just have one statement in that I've done multiple scenic view protection reviews. The code does provide that you can move a building site and develop a structure that breaks a ridge line if you have no other alternative. In this case, there is an alternative, and it is to develop the house as proposed on the edge of the meadow, as we've proposed. It's also been my experience in multiple land use cases that it's not appropriate to rely upon landscaping to justify the location of a house that breaks the ridge line. In certain instances, as David Gerstenhaber knows, the county may allow someone to plant trees if there's been a mistake made and a structure does break the ridge line. But in most cases, if a house is erected or breaks the ridge line The county's gone so far as to ask that the structure be removed before you get a CO, and ridgeline breaks are not an acceptable approach for planning a site when there are alternate sites, as there clearly are in this case.
Just to respond to what he said briefly, yes, go ahead.
I just wanted to ask one question of Glenn, please, not a response.
Okay.
Thank you for sharing that with us, Glenn. I was wondering, these other cases that you were involved in, did any of them have a 1984 agreement with the county?
No, but in other
Thank you.
cases,
That was all.
It's okay, I'm fairly got that.
fine.
May I address one?
You may.
I think we're all in agreement that, the parcels on, Star Mesa can build up to 15,000 square feet. The key words being up to, is my view that something can be built on that parcel that is not 15,000 square feet, that does not break the ridge line. So for economic purposes, again, that's why you're here today.
That's just simply not the case.
Okay.
We've erected story poles and it's not possible.
You erected them the day before.
You know, you're not gonna get anywhere debating him, I don't think,
Okay.
Mr. Shear.
Thank you.
I appreciate your concerns, and I'm gonna, at this point, unless somebody's dying to make a comment that they can't hold in. I'm gonna close this portion of the hearing, the evidentiary portion. And bring it back to me for a decision. First, I want to thank you all for your civility and decorum here. It's clear that this is an important issue to all of you. And issues of this kind can evoke emotions, and I appreciate the fact that you've all been witness to one another and help me keep this meeting under control. So thank you very much. I agree with you, David. This is an unfortunate hearing, but I think it's for reasons other than yours. I'm gonna say some things that I think will offend probably everybody in this room here in making my decision, but I'm gonna go through this step by step. First of all, I understand there are substantial factual and legal issues regarding the 2015 building envelope, whether there was proper consent for that or not. That is an issue beyond my jurisdiction. It's a matter of contract and perhaps other relationships among the parties, the various owners. But I'm not in a position to decide a private dispute about whether there was compliance with the covenants in connection with the identification of that 2015 envelope. It's just not for me to decide, and that's very consistent. This issue comes up regularly when we have hearings regarding properties within HOAs, and my position has been the same in every case. If there's a private dispute, it's beyond my jurisdiction. I'm here to rule about code issues. That's it. Some preliminary, I will call them, issues that were in the written submissions, not commented on today. There was a question about APSHA's jurisdiction to the county's jurisdiction to proceed. As far as I'm concerned, whether or not the individuals here are speaking for the association or speaking for themselves, it's not important to me. I think everyone is entitled to participate, and I've allowed you to do that. And I don't think that there's any impropriety relative to standing to make comments. There's been an issue raised about the county's jurisdiction to impose requirements based on scenic foreground regulations, and presumably all other regulations, including activity envelope and site plan approval. based on the argument that the Penobscot agreement created an exemption from all regulation. I disagree with that. Number one, the Penobscot regulation doesn't say that. Penobscot regulations, agreement says that there's an exemption from growth management regulations, which were in effect at that time. And it does not address regulations adopted subsequent to that agreement. It says that building permits are required, quote unquote, under appropriate zoning regulations. And says nothing further about the application of other rules. The ones that, the regulations that are being applied here were adopted subsequent to this agreement, as I've mentioned. My reading of the Colorado Vested Rights statute is that in the absence of a site-specific development plan approval, which there has not been for this property, subsequently enacted regulations can be applied to this property that are effective at the time that the application is submitted. And there's also an exception for rules of general applicability that apply to all properties equally in the county, and that is the case here as well. And so I do believe that county has jurisdiction to consider this application, and in particular, the applicability and compliance with the senior foreground regulation. The reason that I said this is an unfortunate hearing is that I think that, in my view, reading the Penobscot agreement, control was in your hands here. Control is in the hands of the HOA. The first line of paragraph 5 of the covenant has not been commented on by anyone here. And it says, the corporations agree to impose covenants on the parcel to achieve compliance with the narrative requirements in paragraph 5. That's the vehicle for enforcing paragraph 5, the HOA covenants. There's nothing in that agreement whereby the county retained jurisdiction to review the covenants, to enforce the covenants, to even enforce that agreement. It's pretty clear from the language of paragraph 5 that that agreement delegates to the HOA the responsibility to adopt and enforce all covenants regarding the location of development within that HOA. Something went wrong. And it's not fair to say that the county is responsible for cleaning this up. The county, if it wanted to say that this paragraph 5 was not being complied with, would have to bring a claim against the HOA. It's not these are not self-effectuating requirements. It's clear that they are to be enforced through the covenants of the HOA. So that makes a big difference as to the requests that I, as a hearing officer, would make a determination about whether this proposed activity envelope and building site meet the requirements of paragraph 5. I don't have that. It's yours. And it's pretty clear that you have private disagreements about process and the substance of those requirements, but it's all between you. If I've read the covenants, and the covenants don't have anything in it that gives the county a review authority over the covenants that need to be adopted to enforce this provision. It's all up to the owner. There's nothing in the covenants that include a provision reserving to the county the ability to enforce those covenants. It's all up to the members of the HOA. I don't know what happened in 2015 and whether or not that's valid consent or not. You obviously have strong disagreements about that, but I can't decide. So this is going to have to go somewhere else for that determination. unless you work it out. Um. Regarding the merits and the, consideration of county land use criteria, in the written submittals, there are some issues raised that were not discussed, and I want to comment on those because it is part of the record. Concerns have been expressed about wildlife. I appreciate that as a very legitimate concern in this location. Anyone who's ever driven around up on McLean Flats knows that a lot of elk around there. But, I am persuaded by the experts on that issue here. Jonathan Losky and the Division of Wildlife believes that the impacts on wildlife can be mitigated satisfactorily. I would note, in connection with that, Mr. Losky's comment about the zone of influence. And that the zone of influence, for this development is within the existing zone of influence of the existing development out there. In other words, it doesn't extend that impact beyond what's already existing zone of influence. The planning issue may have some merit. No one's really addressed clustering here because it's not a requirement, but the other side of the argument on the location of this building site, planning criteria and planning thinking has evolved quite a bit over the last 30 and 40 years. And there may be legitimate reasons for the location of this building site beyond what's stated in paragraph 5 of the Penobscot. I'm not deciding that. I'm just saying that there's another side to that story. The water issue has been raised, but it appears to me that both as to domestic water and irrigation water, the applicant has met its requirements with the necessary permits and reporting, both the water wire and with respect to the well permit. Of course, the visual impacts is in this case, the most significant land use issue. I want to make one thing clear that as far as the representation by the applicant, that there is no other developable site on the property, I'm not making that determination. And while I'm going to approve the application, it is not based on that allegation by the applicant. I don't have enough information here to know. And the county code, while it has some specific requirements with respect to scenic overlay review, also has provisions that allow the county to modify its requirements in the event of for example, a takings type claim if there's an issue with the approval. So I'm not including that in my decision. But I am going to approve the application because I believe that the county's land use criteria are satisfied. I agree with the proposed determination, although Tammy, where it says recitals, I'd like that to be changed to findings of fact. I've been involved in recent litigation where the difference between recitals and findings can be legally significant. So that's an important change. I also am going to want to address some of the conclusions of law that I, quote unquote, that I've just stated for inclusion in this determination. So that my position is clear if and when this thing, and my decision gets to, or there's other litigation about this application. So let me see if I've addressed everything I want to address. Nope, I don't have anything else to say. I will get an amended Tammy and I will work on getting an amended resolution, or determination rather, put together and sent out to all of you. For your consideration as soon as possible. Hopefully we can get it done by the end of this week or early next week. Thank you all for your,
Mr. Smith, can I ask you a question?
you have not been able to.
Somebody's trying to ask a question.
Oh. For purposes of a final determination, would that be today, or is that the date of the resolution when it's signed?
As far as I'm concerned, it's the date when it's signed.
Okay, thank you.
Now, I'm not qualified to tell you if Rule 106B, is in agreement with my opinion, although I have looked at this issue from time to time. But I think I'm correct that for purposes of Rule 106, it's when I sign it.
My understanding is that any appeal would have to go to the Board of County Commissioners before it went to 106. Is that
Please.
correct?
Yes, I'm sorry, I could have not anticipated that would be a Rule 106 issue. There is a further administrative appeal to the BOCC, that's correct.
Time frame. Sorry, just double check.
15 days. To the BOCC.
It's 15,
15 days after I sign for BOCC.
15 working days of the decision, so.
Everybody can rely on what I'm telling you. My decision is not final until I sign it because I'm addressing. I want the determination to address issues that are not in this document. This document is insufficiently precise to be considered final decision. Okay? Is there anything else that I
No,
can
thank you.
address for any of you?
Thank you.
Nice job.
Thank you all very much. I appreciate your participation and I hope you can get it worked out.
Who did I borrow the pen from? Thank you.
Thank you.